Oh no, I can't restart my video. I'm back. All right, everyone. Happy Monday. I hope everyone is doing well. Uh, I am pleased to be back on your screens with Lauren Shadley this time. We're here today to talk about Gladio in practice in Nunavut and beyond. Please feel free to interrupt us by raising your virtual hand if you have any questions or comments that you'd like to share. I can see that we've got a wide variety of folks in the room today, so looking forward to hearing from everyone who's interested in participating your own views and experiences when it comes to Gladue. I don't know that we've got like a super uplifting presentation for you today. So um, please feel free to, chime in. We'd love to have a collaborative session where possible. So I think the majority of folks in the room know about Gladue, but I'll set the stage just a little bit. Gladue, of course, was decided in 1999, and it required courts to consider using the unique systemic and background factors that affect Indigenous people when imposing sentence under Section 718.2E of the Criminal Code. This decision marked a formal acknowledgement of the impacts of colonization, intergenerational trauma, and systemic discrimination over the past 25 years uh, on Indigenous involvement in the criminal justice system. Sorry, in the years prior to 1999. Over the past 25 years, however, since that decision, Gladue has evolved through cases like Ipili, which reaffirms that the courts must meaningfully apply Gladue in every case involving an Indigenous offender, regardless of the seriousness of the offense. Despite the legal evolution, Indigenous over-incarceration has continued to rise, to no one in this room surprise, highlighting gaps between Gladue's intent and its implementation across jurisdictions. Gladue remains a crucial, though inconsistently applied, tool meant to promote proportionality, reduce over-incarceration, and open space for culturally appropriate, community-informed sentencing approaches. So, talking about all of that today, we have Lauren Shadley, who received her LLB from the Université de Montréal. She's also got a Bachelor of Arts in Psychology and Political Science from McGill. She's called to the Bar of Quebec in 2017 and admitted to the bar in Nunavut in 2020. She is a partner at the boutique criminal law firm of Shadley Nur and practices criminal and disciplinary law across Quebec and Nunavut. Lauren has defended a wide range of serious criminal charges, from sexual offenses to narcotics and large-scale fraud prosecutions, all the way to homicide. She's appeared before various levels of court, both in Nunavut and Quebec, and has conducted jury trials and successfully secured a faint hope application. She is a former president of the Law Society of Nunavut and is very pleased to be here today. I hope you enjoy this cute photo of Lauren and I sitting in the back of a co-op truck on the way to an Inns North. I can't remember where we were, but went into the archives for that one. Um, I'm also presenting alongside Lauren in this one. I have my JD from the University of Manitoba. I'm halfway done my master's in criminal law and procedure at Osgoode, called to the bars of Nunavut and New Brunswick in 2019 and Manitoba in 2020. Uh, I run Perry Law, which is in Manitoba and Nunavut, and am the vice president of the Indigenous Bar Association. All right, so we are going to talk. This little session map that you'll see on your screen is what we hope to cover today. I've been quite ambitious in planning this session, so we will see what we get through. But we'd like to start with the evolution of Gladue, then get into some case law in Nunavut. Um, Part of my master's, I wrote a significant research paper which did a review of the last 5 years of case law in Nunavut, specifically focused on Gladue application and kind of tracking how the court in Nunavut has considered moral blameworthiness and applied that to sentencing. I'll talk about it later, but basically, I had hoped to come out with a pattern, a clear pattern of how the courts have applied moral blameworthiness, but unfortunately, no clear pattern emerged. We are also going to do a comparative overview of cases from across Canada and that's where Lauren will come in, uh, as compared to what's going on in Nunavut. We'll talk about the tensions, shortcomings, future directions, and hopefully get to an interactive discussion. However, feel free to just pop in whenever you want. Great. So I'll pass it off to Lauren.
Great. Thanks, Victoria, for the introduction and setting all this up. I do see we have some pretty senior people on the line. So please feel free, I mean, everybody, but particularly those with quite a bit of experience, to jump in, add examples, ask questions. This, I think, would be more beneficial for everybody if there is some discussion, considering we all practice in the field and want to know ways to move forward with these issues. So the title of the presentation, as Victoria said, is In Nunavut and Beyond. Vic graciously assigned me the beyond. So I've gone through case law at the appellate level across the country to kind of pull out some trends and give you some names of cases where there are things that might be particularly useful. I have 10 minutes, so bear with me. I'll try and go over them quickly. But later on, there is kind of a comparative interjurisdictional discussion where we'll be able to pull out some of the themes. If it looks like I'm reading a lot of cases, and I have a lot of notes, so I apologize, bear with me. I'm going to start in Alberta. A lot of decisions out of Alberta. We're going to start with Yellowfly. The citation is 2025 ABCA 381. Probably don't need this one. This is one of the outlines, and we're going to see in all of the jurisdictions, there is that tension between what to do when you have an Indigenous offender and dealing with IPV, intimate partner violence, and the victim is also Indigenous. That's an issue that comes up across the country, and thankfully is now before the Supreme Court in the case of Cope, which is supposed to be heard, I believe, Victoria told me, in 2 weeks. So very interested to see how the court is going to deal with that tension between those two sections of the code. Anyone who's been on circuit in Nunavut or has appeared before Justice Cooper, I think I've heard her explain the tension between those sections at many sentencing hearings, and I've heard that in Quebec as well. So interested to see what the court does. There is an interesting decision out of Alberta that dealt with record conversion risks. So it was one that kind of a different application of Gladue, which is why I'm mentioning it, that we should be more careful on youth sentences because the longer the sentence, they don't want it to risk converting and the impact that would have there. Unfortunately, the judge here, the appellate court, didn't agree, and they said that collateral consequences of the record conversion should not play in. I would disagree, and I'd like to see that argued in other jurisdictions, but one to mention. The next one, and this is something to talk about later, so I'll flag it now, is what to do with Friesen in a kind of post-Friesen jurisprudence. That it's kind of known that we've seen that tension before between IPV and Indigenous offender, but now we see that appellate courts across the country are kind of dealing with the tension of what to do when you have all of the Gladue factors, but it's a case where you also have to apply Friesen. So we have Alberta, the citation is RV Green 2025, ABCA 314, where the court says that The judge was under the misapprehension that Friesen limited the ability to attribute full weight to Gladue factors, and says that what the judge did in this circumstance is she already decreased it to what she thought would be an appropriate sentence. And the court says that she did not commit an error, but they provide a lot of language on how to provide, or how they think you should provide weight given Friesen. Another Alberta one, there's a lot of Alberta, I'll skip ahead soon, is they're looking at where they fail to give sufficient weight to Gladue factors. And this comes up often, we'll see it later, but that the appellate courts cannot intervene simply because at first instance you don't like how it was weighed. So a theme that will come up is that a lot of deference is granted to the first instance judge in general on sentencing, but specifically when dealing with Gladue factors, that just because you don't like how the factors were weighed or you think they weren't weighed properly, you're going to have a very hard time getting the appellate bench to agree with you. They give a lot of deference to the first instance judge. A couple more cases that deal with the COPE issue that we're going to hear soon. One from Alberta that is useful, kind of for defense anyway, is Phillips 2023 Alberta Court of Appeal, where the appeal was granted in this one because the judge did not properly assess the factors and dealing with moral blameworthiness. I'll let Victoria explain moral blameworthiness a bit later because she's the expert on that now. But what happened here is that the judge basically said that the accused had not sought any treatment or rehabilitation, and that was aggravating. Instead of kind of applying the history of substance abuse dislocation and applying the Gladue factors. If we go to Saskatchewan, I mean, we've seen many courts do this, but RV CWAP 2025 SKCA 114, proper application of 718.2E will not always result in a different sentence for an Indigenous offender. So often we'll see counsel try to appeal a case and say, well, there was Gladue factors, how come we didn't get a lesser sentence? Just because those factors exist doesn't mean you get a lesser sentence. They have to be considered, and there has to be a nexus or a link. And only if that's established, then maybe there will be a reduction or that will be taken into account on sentence. And then we have another one from Saskatchewan, also 2025, RV Lerat, Lerat, where they very clearly, the court says, factual determination that the Gladue factors did not have any impact on his moral culpability. Another 2025 Saskatchewan Little Wolf. This one was interesting that the judge has to consider Gladue factors even if the joint submission doesn't mention them. So in this one, the Court of Appeal writes a joint submission does not eliminate the obligation imposed by 718.2E to consider Gladue. And the concept of restorative justice and decision in Gladue in particular returns repeatedly to that concept in explaining how it is that sanctions other than incarceration might satisfy the sentencing objectives. So even if it's not brought up by either counsel, the judge still has to inquire about it. Let's go to Manitoba, keeping an eye on the time. In Henricks 2025, MBCA 101. In this one, the appeal was because the accused, they're saying the accused rehabilitation should have had more weight, and that the judge's decision to give less weight to that principle was unreasonable. The Court of Appeal disagreed and said, when principles of denunciation and deterrence are primary sentencing objectives, circumstances personal to the accused take on a lesser role. That tension we've seen many times. People are still trying to appeal it, but they don't get very far. Where there are kind of those tensions that I think we need to see resolved is more the case of COPE and also dealing with Friesen. There's cases from Manitoba that address both of those. I'll skip them unless anybody wants to hear them at the end. There was a 2022 case that kind of similar to one I mentioned before, where the judge basically considered that the individual was responsible for their own misfortune and negated the myriad of Gladue factors. That one, the Court of Appeal allowed and gave a new sentence. Before I go to Quebec, a brief pause in terms of how many of these cases there are, because I do think it is interesting. There was a study done in 2020, I believe, where they looked at how many cases mentioned Indigenous offender at the Court of Appeal level. And when they put the parameters of 2019 0101 to 2020 1231, they only had 28 results at the Court of Appeal level. And then the author of the paper goes through and says, of those 28, 13 at the trial level, Gladue was considered but given no effect. On appeal, 9 of those 13 times the Court of Appeal disagreed. So they thought that the Gladue factors should be given effect. I redid that just to see kind of where we are now, in case law and what's going on. So I put in the parameters 2023 0101 to 2024 1231, and there's 60 something, 65, 66 Court of Appeal cases that mention that terminology. So I think they're definitely taking more notice and making sure that Gladue is more applied, but we'll talk about that a little bit more, just kind of planting that seed so when we get to the discussion. So Quebec, there was an interesting decision that came out last week. Young offender was given 2 years less a day. He was driving in his community. He was driving in a state of intoxication. He had 10 people aboard his truck, got into an accident, and one person ended up dying in that collision. The judge, there's no written decision yet. It was just in the news, but the judge was very clear to say there is no automatic discount just because the factors are present. There has to be that link to the individual. And only then can there be a consideration of if there are other sentencing options besides incarceration. And while the Crown was asking for a very high sentence incarceration, they did get 2 years less a day in the community. Quebec Blacksmith 2023 Court of Appeal 1238 appeal allowed sentence. They sentenced a decision of 5 years is substituted to an 18-month CSO. In this one, they basically said that they did not take into account the factors. So that's kind of a great one from Quebec, and always happy and surprised when Quebec does the right thing. Then 2023, another file basically says just because there are 718.2 factors doesn't mean automatic reducing. So that comes up very often. Also ones from Quebec dealing with intimate partner violence. We go to Ontario quickly. Bunch of decisions again where they're trying to appeal by saying the judge didn't balance the factors properly or didn't give enough effect to the principles that come out of Gladue. And the court saying, we have to be very careful and give the trial judge deference. And as long as they see the trial judge was alert to it, they're very hesitant to grant that as an appeal. But then there was D'Souza 2025 on Ontario Court of Appeal 289, again saying no requirement sentencing judge have to use it as a discount. And then there also says that there's no requirement the sentencing judge link the Gladue principles to the assessment of moral blameworthiness per se. I'll leave that one for Victoria to comment on later. Again, Ontario, they're saying just because there's factors doesn't mean we get a different result. British Columbia, quickly, we're running out of time, still good. British Columbia, they grant, there's the Izzard case 2025, BCCA 2014, assessment of moral blameworthiness, but not equally important to the assessment of seriousness of the offense. This also could be a tension that might go up to SEC in my opinion. They're looking at, what to do if it's a very violent offense and when to pay particular attention. Another one from BC, Gladue factors necessarily form part of offenders' personal circumstances and are consequently relevant to the assessment of moral culpability. Those I'm flagging for us to talk about after Victoria goes into moral blameworthiness. There's a few from BC where they say because the person was Indigenous doesn't mean they get that credit, but they actually give more analysis to show how there isn't a link. So somebody who, for example, lives in the city, doesn't have connection, is doing very well, and then tries to say, well, my family or my great grandparents or grandparents underwent trauma. The judge says you haven't done enough to really show that link. Then there's ones that also say, also BC, there's also one from Ontario. Raising Gladue for the first time on appeal is not an avenue for appeal. It has to be mentioned by counsel at first instance, and failure to mention it won't give you a direct route to appeal. So you have to be ready at trial or at sentencing from trial to present those factors. If we go to the Maritimes quickly, again, there's cases that say it's not automatic reduction of sentence. There has to be some basis in the information or evidence to explain a relationship in the circumstances and particular to the individual. And if we go to, there's one that I liked from the Yukon where it kind of touches back on what I was saying before. It's a 2020 decision, but the principles still apply, where it says that the application of Gladue principles is required in every case involving an Aboriginal offender, and failure to do so could constitute an error. So the judge has to ask about it. And if the judge doesn't apply those principles, then it could be a mistake. But how the judge applies those principles and their weighing of it, you'll have a harder time getting an appeal bench in that regard. So that was very fast, but I hope that gave a bit of an overview across the country.
Thank you, Lauren. Oh no, and I'm finding out that my formatting didn't work when I switched to this. Great. Okay, so what is moral blameworthiness is kind of where Lauren has left us. And while some courts across the country have adopted their own interpretation, iteration of what moral blameworthiness is, Nunavut has not, in what I could find, created its own definition for moral blameworthiness. So where does this like term even come from? It comes back from Ipoli, where the court said at paragraph 87 of that case that systemic and background factors may bear on the culpability of the offender to the extent that they shed light on his or her level of moral blameworthiness. And when we're looking at the two-parter that comes out of 718.2E, it's under the first part of the it's under the first part where moral blameworthiness is invoked as a requirement to be considered in relation to unique Aboriginal factors. And so Judge Herodens and Katrina Kaiser-Dick in their paper Shedding Light on Gladue and Section 718.2E really kind of drove home that an understanding of moral blameworthiness must necessarily be set out at an early stage to ensure a uniform understanding of the perspective with which the court in any given case should be reviewing the case law. So the moral blame, oh my gosh, excuse me, everyone in my house is sick. A moral blameworthiness analysis must take place to consider what individual circumstances resulted in the behavior that brought an individual before the court. And once a judge has a fulsome understanding of the degree of moral blameworthiness applicable to that specific individual, then it's the court's duty to exercise restraint where due and impose a just and fit sentence. So when we're looking at the unique context of Nunavut, I'm going to rattle off some things that for most of you in the room are no-brainers. The Gladio was created 3 days. Sorry, Nunavut was created 3 days before the Gladue decision was decided. Nunavut is the youngest legal jurisdiction with the highest proportion of Indigenous residents in Canada, 85.8% Indigenous, and 98.3% of those are Inuit. Nunavut has a very unique opportunity to be a leader in Indigenous justice, yet the Nunavut Court of Justice has routinely self-identified as a Gladue court, however, does not fit the working definition of Gladue courts across the rest of Canada. So, in my case review of from 2019, 2020 to 2025, I found there were 86 published cases in Nunavut, only 27 of which referenced Gladue or moral blameworthiness. So when we take that into consideration with uh, with the case Lauren raised from the Yukon, where the judge must be considering whether an individual is Indigenous, where we have a population that is 85.8% Indigenous and only 27 cases out of 86 reference Gladue or moral blameworthiness, I think that should raise raise a bit of concern with respect to how Gladue is being interpreted in our territory. In those 86 published cases, there was only note of one Gladue report that had been filed and considered by the court within those 5 years. There were 13 pre-sentence reports that contained a partial Gladue content, as were referenced by the judge, of course. There may be something else that wasn't referenced, but that's what the case law tells us. The majority of the decisions that mention Gladue, of those 87, are at the appellate level, the Nunavut Court of Appeal. So that's really signaling a heavy reliance on the Court of Appeal to consider Gladue and to ensure that the Nunavut Court of Justice is deciding things in a way that is in line with the law Canada-wide. So in most cases, moral blameworthiness was articulated in those 27 cases. However, it didn't mitigate the sentence. Instead, it often was used by the judge to justify a harsher sentence. There's only one case out of those 87 cases that where moral blameworthiness was used to significantly reduce a sentence. And so, not that moral blameworthiness needs to be something that reduces a sentence necessarily, but where you have it as something that's supposed to be considered under Section 718.2E, which of course is the idea is it's a mitigating factor, where you only have moral blameworthiness being used to increase the sentence rather than decrease, it's a bit alarming. So in this review, and I've got kind of my favorite cases here up on the screen. In this review, courts have struggled to connect Gladue factors to moral blameworthiness specifically. What I determined was that there was a lack of causal reasoning and or a refusal to attempt to do that causal reasoning in their decisions. And in several cases, courts deemed personal colonial experiences as insufficient to lower an individual's moral blameworthiness, of course, contrary to what we see happening nationally. Instances where the courts in Nunavut cite a defender's pro-social life has been used to reject Gladue mitigation and repeated judicial statements that certain offenses, for example, discharging firearms and sexual offenses, uh, are inherently indicate high levels of moral blameworthiness and therefore limit the Gladue impact. So the concern coming out of that is that Gladue becomes something courts can acknowledge, but then rarely allow to follow and actually affect sentencing outcomes. So my five top favorite cases that came out of this review were Itirilagak, where the court assigned heightened moral blameworthiness despite IQ being cited. Okout, where the court found that Gledu factors overemphasized and imposed a harsher sentence. Algiak, where some Gledu consideration was allowed, however, moral blameworthiness remained high. And Simialik, where which was the only case where moral blameworthiness was found, uh, to significantly diminish due to the offender's personal residential school experience. And then finally, Ikidluak, which is one of the very few really detailed analyses that I found in the last 5 years of Gladue factors. And ultimately, it resulted in a multi-year incarceration despite the Gladue factors that were considered. So, my critique really of these cases is that the court lacks resources and capacity to conduct a Gladue moral blameworthiness analysis. Uh, Kind of in the same vein, counsel are also struggling to provide adequate evidence that connect background to moral blameworthiness. Really, as is our job somewhat, but also as is the job of a Gladue report writer. So and I know we've got a few in the territory now, one or two, um, and it's difficult to put out these reports in a timely manner. But without Gladue reports, sentencing judges are really only relying on inference, which, in my opinion, has led to an inconsistent and often more punitive outcome for our clients who are before the court. And so I propose that if we were able to make a significant investment in Gladue report availability and cultural expertise of Gladue report writers, including perhaps training some Inuk elders and other Gladue writers who are trained in IQ, that could shape how we move forward in this territory. So I'll pass it off to Lauren to take us back to a more comparative interjurisdictional discussion.
It's just from what you just said, I think it's interesting the mention of kind of Gladue writers because there is a lot of yes, difference in the quality of the reports that you get. I don't know if that's because of the writer's training, ability, experience, um, or lack of kind of getting response from the family or community that they're trying to write about. But I've recently seen kind of Gladue reports where a lot of background information about the particular community where the client was, very little about the individual or connection to the individual. This particular Gladue writer was a university student who seemed very interested in the community they were writing about, but said they couldn't really reach family, and there was very sparse in terms of connection. So that doesn't help.
Sarah White, sorry to call you out. I would just, if you could please, we could just hear you. Thank you. Sorry, Lauren.
Was it because you wanted to add something, Miss White? No, maybe a cat stepped on the mute button. All right. And then you'll get other Gladue reports that kind of super in depth do kind of all the work for you as counsel and do kind of an in depth speak to family members, speak to friends, do a kind of background on what the person has gone through, etc. But difficult for counsel at the courts when you're dealing with that disparity of the quality of writers and then the quality of information. And the courts can only make decisions on the information that's brought to them. So I think, Victoria, I echo the need for resources into training writers and providing programs for that. In terms of interjurisdictional discussion, different provinces are trying to have Gladue courts or programs. I think some more effectively than others. What we see across the board is a lack of kind of resources and funding, and also the kind of the differences in trying to meet all of those. So, for example, in Montreal right now, at the municipal court, there's a Page A program, which is a program for Indigenous uh, offenders to be able to do kind of more community focused programs and be able to speak to elders. I know in NWT and Yukon, there's a domestic violence treatment option, there's wellness courts, there's relevant court ordered programs. In Saskatchewan, there's Cree speaking Gladue Court that deals with the North. And then I believe that there's also one in Meadow Lake that you could have hearings in Dene, Cree, or English. They also have there's courts across the country that are trying to deal with implementing or try to focus more on implementing more sentencing circles and going to that circle model. Toronto's been doing that. There's the Aboriginal Youth Court in Alberta that's been trying to do that, the Justice Court in Toronto as well. But it's quite difficult to do when there's not as enough resources for it. It's also, I find, if I've been in the situation, I don't know if others on the line have been, where sometimes if you can't get a Gladue report, for example, there's just no writers, and then you'll try, I think this issue was up actually in Nunavut, you'll try and get an elder or somebody to come just speak about the community and what it's been through. You can't get that person qualified as an expert per se. And a lot of the information that I also had one in Quebec where I was trying to get it in at sentencing, and at sentencing is more lenient in terms of the information that you can bring. The judges don't know how much weight to put to it. Whereas they do have this report that they would put a lot of weight to, should we have kind of a strong one. In Quebec as well, I guess all over the country, there's starting to be the use of IRCAs, kind of similar to Gladue and kind of taking into account background. IRCAs are the impact, race, and cultural assessment reports. Um, Interesting note on that, the federal government gave funding across the board for those to get writers and get those started. Unfortunately, where I normally live in Montreal, Quebec said that they don't need the funding because there's no need for those reports in Quebec. So we could see how that will cause a huge disparity across kind of the country as well. If that's not necessarily a resource thing, but if one province is saying, well, we're not going to use those reports, we're not going to get that information before the judge. So I don't know if that was really a cross interjurisdictional discussion, but definitely a discussion of different courts and things that we could have and we could be doing. But I don't know if we want to go to 5 of where we're falling short.
Yeah, let's talk about where we're falling short. I'll yap first, Lauren, since you just had a mouthful there. Well, I'll say that in Nunavut, and I don't know that any of this is going to be groundbreaking for the group that we have in the Zoom room today. But in Nunavut, courts often fail to articulate how Gladue factors impact moral blameworthiness. It's the kind of the major finding from my paper. The courts in Nunavut will often treat Gladue factors as insufficient unless their circumstances are extremely severe. And I would posit that the Gladue circumstances affecting the majority of Nunavummiut are extremely severe in most cases. However, I would suggest that the courts may be somewhat desensitized to the level of factor factor affection that Nunavummi are living with and face because it's so routine in our court system, as where if we had an individual in the circumstances that a lot of the folks who come before the court in Nunavut have living down south and in a major urban center, if they had the same factors of some of the folks that we deal with on a routine basis in Nunavut, I think their Gladue factors would be thought to be quite shocking. And would militate towards a greater application of a moral blameworthiness analysis and therefore mitigation under Section 718.2E when it comes to sentence. I think that the court potentially, and this might be a hot take, but I think that the court potentially, when they consider themselves this Gladue court, what they're actually saying is that they've become a bit desensitized to the circumstances of Indigenous offenders because they deal with them so regularly, and they see these circumstances before the court every day. I would say that the courts rely heavily on prior case law that privileges denunciation over restraint, and that they rarely adopt Indigenous informed sentencing, for example, land-based or community-driven sentences. Um, in GH, which is a Nunavut case, um, where the councils put forward an on the land sentencing as proposed instead of a carceral sentence. The court dismissed that as an option despite its alignment with Inuit Kalimayakkinji. I'm not leaving Lauren really with a super, you know, bright picture to follow. But what's your thoughts here, Lauren?
Yeah, I would agree. I think there is kind of a bit of a desensitization, but I was thinking that I think it's also slightly unfair when an individual has kind of thinking back to what access the Gladue writer or counsel may have to get information. If an individual has lots of family members that you could speak to, or friends, or a counselor or social worker that you could get all that information from, you could put it before the court, and know some of that history in terms of Gladue factors. But then the individuals that usually could be suffering the most will likely not have those individuals or support that we could speak to, and may have difficulty remembering or articulating all of the factors that should be mentioned in a report. So as you were talking, Vic, I think I would agree there is some desensitization. And I know, from my experience, when I've mentioned some things in Montreal, it gets a much stronger reaction just because there are things that they haven't necessarily heard. But then, I imagine on the other side, there's certain types of crime in Montreal that the judges have heard and they hear every day that if I argued up here across the street, I'd probably get a different reaction. So I don't know who or if anyone is really to blame for that. But I do think there's also something to be said of how do we get the information on individuals when they don't have those kind of family members around and supports, and it gets much more difficult to do. Have a case coming up here where it took 7 or 8 years to get this individual into treatment. And because of that, now I have kind of more of a wealth of information about the individual. Whereas comparatively to down south, if somebody wants treatment, I could get them into, dozens of different programs by next week. So it's also, I think it goes back to a resource issue that I think particularly in Nunavut, we do see courts calling that out, and kind of, I can think of one decision particularly that Chief Justice Cooper rendered some years ago of kind of asking the federal government to do something about it. I imagine Miss Bedford, who's on the line, remembers that one. It's the one that has the Bedford affidavit in it. But
Sure do.
I'm not sure what more courts could do. Julie, any thoughts?
I wish I had some thoughts and suggestions. Unfortunately, nothing to add.
I
It was
have,
on.
sorry.
Sorry, go ahead.
I feel like, we kind of have these same discussions over and over about what what should be done, what the higher courts have said needs to be done, and what's not being used and not being implemented. And it always does come back to this resource issue. Um, it's just, I find it to be quite, I don't really know what the word is, you know. It's like there's all the answers, there's all the reports, there's, approaching hundreds of different kinds of reports and calls to actions and calls to justice and like um people speaking up and saying what's needed. And it seems like the path has been there for so long, but I think, in my opinion, maybe what is the root cause is it's like a government lack of interest in resolving the issue because all of these things, in my opinion, go back to why can't we just prevent it? And we need more resources in the prevention stage. And governments don't love to devote dollars to things that aren't sexy, like prevention. They want to do things that are sexy and current and make great front page news, like increasing or changing the bail reform, doing bail reform, right? Um, as where if we had more treatment centers, more assistance for families on the front end, there might be some actual change.
Yeah, but again, Victoria, like these aren't, as you said, these aren't new things. I went and pulled up the paragraph. It's TQ 2016, so even further than I thought. It's almost 10 years now, where Chief Justice Cooper writes, I'm advised that there is no treatment available. Essentially, what we have accomplished through the court process is to simply diagnose and label a problem, but nothing further. The situation is similar to having a medical doctor diagnose a broken leg, recommend a cast, and then not have the resources available to put a cast on. Um, I remember reading that before my interview to move up here and be a staff lawyer with the Legal Services Board of Nunavut and thinking, that that's crazy. Like in when I was working in Montreal, the issue is never a lack of treatment options. It's trying to convince your client and getting your client to go there. And I was curious of what it would be like when I moved up in 2020, because this was already a 2016 decision of what there would be. And unfortunately, my experience is there weren't many other options. There's now a couple more, but still, I would agree with Victoria. It is a resource issue, and I don't I don't know if necessarily just a money one, because even when there are programs and there's money put to it, it's then getting the people and training the people and having the human resources involved to use those kind of dollars and cents in proper ways, where we do get writers and courts that have different streams and treatment options, because it's not everywhere where you have these diversion programs that I think when we do see them, they're quite effective.
I'd love to pull in our folks that are hanging out in the room with us today for the last few minutes here. We've presented a series of problems with how things are going with respect to Gladue, and I'd love to hear some weigh-ins, maybe some potential solutions, some friendly commiseration. If anyone is interested in joining this discussion, please raise your virtual hand or just feel free to unmute and join in.
Um, I I can't find the button to put my hand up, but it's Jessica here. I just want to kind of reflect back, I mean, some gratitude to both of you for the research work and for taking the time to articulate clearly sort of an evidence-based expression of something that I think I'm sure many people on this in this room, virtual room, share that same kind of sense of ambivalence and way that the solutions don't seem to be happening. My time arc with this stretches back to 2001 in the territory, with legal aid and with the Crown's office. And certainly, um, there are times when, despite the utter like sort of lack and inadequacy of resources, there does sometimes feel like there's more to offer in terms of formally structured resources than there once was. A case that predates that Cooper case, some people on the call will remember Justice Kilpatrick in Joe Me, I think was the name of the case, where he called out. I think at that time we only had Wednesday afternoon for a couple hours, like mental health worker who was dealing with probation orders, like for everybody in the in all of Iqaluit and I think some other places in the territory as well. We're all getting funneled to that one person. And the court was ordering alcohol treatment and anger management and all this kind of stuff, like all these types of counseling on almost every probation order. And yet there was like utterly impossible, like it was physically impossible for clients to even meet that condition. Because there was no resources and Justice Kilpatrick would have, I don't know, his veins would pop out of the top of his head sometimes with frustration and eventually issued that decision. And I think one of the upshots of that decision was that they increased the size of the bench, maybe. I think in response to that in the territory was one of the issues that came up around that time, maybe in like 2008 to 2012 timeline. I don't, anyway, sorry, I'm just kind of commiserating here, but I think Jonathan Rudin's research from, 15 years ago on Glad You Report, 10 years ago on Glad You Reports out of the Toronto Aboriginal Legal Services group, about the downstream effects of Glad You Reports. Oh, thanks, Sarah. Yeah, you were around for that. Uh, is also something that like I always have felt really concerned about when Glad You reports get into the mix. He had some really striking research, and I mean this is from over a decade ago, about the impact of a Glad You report on correctional classification. And that, that downstream impact. Sorry, I'm supposed to be in court in a couple minutes here. Um, so the those downstream effects on correctional classification and how not only is the court not considering things like moral blameworthiness, they're not actually, at least Glad You factors are not helping our clients, but they're also then actively harming by raising things that are then perceived by the correctional system or the family law system, et cetera, as, so I think there's almost an aspect of needing to, I don't know that defense counsel actually adequately warn their clients. I'm not sure that we're doing adequate like risk warnings, and that if this was a commercial relationship, we would have like a liability issue that we were not adequately warning about downstream negative impacts. Or if it was academic research, for example, there would be ethics review reasons where we would have known risks that we had to identify, articulate, and then explain that there was a high likelihood of this having a negative effect downstream for that client or on it. And I mean, we do warn to some extent, but it just seems so minimal. And uh, anyway, sorry. Yeah. Thank you guys for all the research. It's really appreciated.
Thanks for that, Jess. Jesse, go ahead.
Hi, can you guys hear me okay?
Yep.
Hi, everybody who I know. I used to practice quite a lot in Nunavut. I was a Crown prosecutor there quite some time ago now, and I mostly practiced in NWT, but I'm as a defense lawyer, but I am called in both jurisdictions still. I just wanted to say, like, I know you guys mentioned the NWT courts here. I wouldn't use those as an example of culturally sensitive or Gladue courts in any way. That's not actually the intention of either court. Um, Wellness court maybe a little bit more, but it's not in any way like culturally attuned to Indigenous people. It's simply more like I would say the equivalent of drug option court in other jurisdictions, um, and not culturally sensitive and not particularly trauma informed. So just noting that the NWT really isn't doing it any better. And also interestingly, like I know that Nunavut still has a ton of issues and that not including analysis in judicial decisions is a problem, but sentences are still much, much lower, which is a positive thing. Like maybe they're not being articulated properly, but I think often for whatever reason, the sentencing range is much lower. And even in jurisdictions like NWT, where I think judges are a bit better at maybe paying lip service to Gladio and Ipoli in their judgments, the sentences in very similar communities to Nunavut, sometimes almost identical. Like you look at the map and the Western Arctic communities are really just separated by a line. People in this jurisdiction are receiving much, much, much higher sentences. And it's just interesting. Not that I don't think there's work to be done, but just on a positive note, even being in court in Nunavut feels much less colonial for whatever reason than it does in Nunavut. Just like the way that judges are open to hearing and sitting and the way they speak to people is very different now that I've been practicing here for a while. So maybe a bit of a positive note in there are so many problems, but it's still, I honestly think Nunavut is doing a bit better than some of the other territories. Maybe
Yeah.
that's just a depressing point from my jurisdiction.
No, I would echo that, Jesse. I think you're right with that. I also have had the experience in Nunavut. Kind of council can share a lot of the Gladue factors. I mean, because we don't have many writers, or we didn't anyway. Now there are one or two, and in all the sentencing, I would stand up and I would explain all of the factors and issues and about my client and where he grew up and his family, etc. You can't do that in Quebec. If I stand up and try and act as kind of counsel sharing that, it's where's the paperwork, where's the justification, where are you getting this from? It's not viewed the same way as it is in Nunavut. So it's much easier, kind of maybe not easier, but they're much more flexible in how they receive the information. It can be more informal, which I think definitely benefits the accused. Yeah. Another just kind of point to tie in terms of the Nunavut sentences being more lenient. I think we see in anyone who follows the Nunatsiaq news as much as I do, it seems like the public doesn't like that. And it seems like there's some backlash in the comment section, which people say don't read, but of course I read them first because I want to know kind of what the public thinks. Kind of just curious. And it seems as though the public is saying stop using their background as an excuse, throw them away for longer, give them harder sentences. And I kind of wish there was more analysis kind of given or explained of it's not just because of the background that they get a more lenient sentence. It's because of the nexus. It's because of that link. Just having grown up in this community doesn't mean you get a more lenient sentence. It's all of the factors, if they're explained and shown how they apply to the person, then the judge weighs that in as one of the factors. But anyway, neither here nor there, just thinking about the differences in the jurisdictions. Any other comments? I think we have about a minute or two left. Vic, do you want to wrap us up then?
Sure, I'll take us away. So I'll just summarize our key takeaways here, which really is that Gladio's promise is unrealized but still essential, that Nunavut shows both unique challenges and opportunities, that moral blameworthiness analysis must be culturally grounded, and reports elders and community collaboration is key. I really appreciate the kind of lively discussion we've had just at the end here. I appreciate everyone taking their lunch hour to hang out with Lauren and I today. And I hope you enjoy this final closing shot of Lauren and I from a different trip. I think actually in this one, I'll close with a little story. I'm pretty sure in this one, we were in Kikiktarjuak and we were walking home from court or home from co-op. We saw a guy unloading a bunch of char from his skidoo, and then we asked him if we could borrow the skidoo, and he's like, "Oh yeah, why not?" So Lauren and I got on it and went on a little ride out to an iceberg trapped in the bay, and then promptly went to co-op and deposited some cash into his co-op account as a thank you, which he refused to take initially.
So just to add to that, I remember coming back and somebody saying, did you two just ride out around that iceberg and back?" And that the ice wasn't very solid, so it wasn't a very smart thing to do. That's how I remember the end of that story. It was still a lot of fun, and obviously we're both okay. But I've always appreciated traveling with Victoria. It's good fun.
Thanks, everyone. Have a great rest of your days, and go forth and glad you.
Thanks, everybody. Bye.